Mark Sargent.
Thank you very much for taking the time. My name is Mark Sargent. I'm a stay-at-home dad from Westport, Connecticut. I'm here to speak in connection with Ray's Bill 494 regarding guardian ad litem reforms. Well, I've been a stay-at-home dad for the last 7 years. Before that, I was a graduate from the University of Pennsylvania Law School. I practiced law at Sullivan and Cromwell on Wall Street. I was then an investment banker, did reasonably well, had a decent amount of savings, basically left Wall Street and actually left Lehman Brothers, fortunately enough, 18 months before Lehman Brothers went bankrupt, and was smart enough to hedge my stock. Little did I know the benefit of that would fall upon the divorce industry and not for the benefit of my children. I have sole legal custody of my 3 children. They spend 7 nights a week with me because of the unique aspects of my family situation. So in a lot of measures, I'm not a disgruntled litigant. I basically have gotten everything that one could really get in the circumstances. I actually would prefer that my ex have more parenting time with my kids, and hopefully we can accomplish that in a way that meets everybody's requirements. I think one of the things that makes me unique is I believe that I'm the only family court litigant in the state of Connecticut to have his guardian ad litem removed for cause. And I think it might be useful to talk about my circumstances and whether or not House Bill 494 would provide more safety for other people. There are a few unique aspects about what I call family law practitioners, one of which is that malfeasance is actually profitable for them because they can continue to bill for the time it takes to fix their malfeasance. So as crazy as it sounds, one of the bills I currently am facing is what I'm told is $25,000 bill from my guardian ad litem for the hearing at which she was removed. And I think a $30,000 or $40,000 bill from the court-ordered attorney who was appointed to defend her against the allegations I had made about her. These are complicated situations. They are, okay? I think when you look at them, and I imagine you guys are confused because some of the people are saying, wow, my kid was taken away from me. Other people are saying, I was a kid who was put with a parent I didn't want to be with. And other people are saying, I don't want to have to give my kid over to another parent who's endangering my child. When you pass the laws that regulate these kinds of things, I think it's useful to look at what people's incentives are in the system and make some simple assumptions. And I think you should assume that the divorce industry is trying to maximize its profit, the parents care about themselves and their children, and that the judges really care about 2 things, which is managing their caseload, which is really complicated, and not being held liable for a bad decision. In my case, I first raised issues about my guardian ad litem when her bill was a total of $81,000. And in my mind, she wasn't doing anything. None of the concerns that I took to her about my ex were being raised. She was obligated to help us negotiate a parenting plan. She wouldn't even comment on any of the multiple draft parenting plans I suggested. She told me that if I didn't pay her, she was going to take me to court and I would be ordered by the judge to pay her, and I invited her to do that. Lo and behold, when I got in front of the judge and the judge said, what is the issue? And she said, he won't pay me. And the judge said, I would be ordered to pay her, and that payment would be non-dischargeable in my bankruptcy. And I thought that was kind of a big deal because he hadn't heard from me why it was I was debating her fee. So I did get the picture, though, that I wasn't going to get a fair shake in front of the judge. I was pro se at that point. I eventually retained counsel largely to deal with what I think is the malfeasance of my guardian ad litem who was eventually removed. In last summer, when I started to make serious allegations saying, listen, this is not okay. You're not acknowledging the concerns I have about the safety of my children. You are not cooperating with the drafting of a parenting plan. You won't even comment on any of the parenting plans that I submit. She got to be what I would describe as very defensive. She tried to, in my mind, justify her existence by making a lot of exaggerated claims about the mental health of my children. And she then asked the court repeatedly to appoint a lawyer to defend her against my allegations. and the judge eventually did appoint a lawyer to defend her against my allegations. The specific lawyer the judge picked by name from the bench is, if you look him up right now, currently named a defendant in 6 lawsuits. The first of which is the plaintiff was the grievance board of the state of Connecticut, which I think fined him $300,000 in something that I think is called a presentment proceeding. I don't entirely understand I'm not a member of the Connecticut bar. So the other 5 are malpractice actions where people are suing this lawyer who was hired to represent my guardian ad litem from my allegations against her for various forms of malpractice. One of them is a person who spoke previously who alleges that this lawyer tried to extort him into paying a bribe to get a quick and favorable custody outcome. The lawyer for whom he is accused of extorting the bribe was my ex's lawyer at the time this counsel was appointed to represent my GAL. The guy who gets appointed to represent my GAL, then, the first time he is in court, asks for a court order that I not be permitted to contact the guardian ad litem except through him, and that I not be allowed to be physically present with the guardian ad litem unless he was there. And I attached to my testimony that I filed an excerpt, a 2-page excerpt from the transcript where you can see that he says, Judge, I don't even have to state a reason why, but I want this and I want you to enter it as an order. This happened at a status conference, not a hearing. There was no motion pending. And you'll note that the judge granted the order. Let's hit the pause button here. I have my kids 7 days a week. It's a post-judgment proceeding. I had sole legal custody of my children, still do. And yet now, in order for me to raise concerns with the person who's supposedly appointed to represent the best interest of my children, I have to pay my lawyer to contact her lawyer to contact her. The next thing that happens, we end up in court on the motion to have my GAL recused, and there is a big issue about whether or not I even had legal standing to bring that. And in fact, after I filed the motion, which I filed as part of my written testimony, the first thing that happened was I got a response saying I had no standing to even make that motion. And clearly the judge that had appointed the counsel to defend the GAL would have agreed with that, but through persistence, a federal lawsuit against that judge, and then a recusal motion that my attorney, Norman Pattis, filed to have that judge recused, she magically sua sponte transferred my matter to a different court, which, having spoken to other parents, is what happens if you actually file a recusal motion against a judge that has some teeth. Your recusal motion is never going to be heard, but instead you might get your motion transferred to another judge sua sponte. So at the first
Mr.
hearing...
Sargent, the bell sounded some time ago.
Okay.
And I certainly don't want to minimize the entire history of your case, but I think the members understand the point.
Okay. If you would like, I can give you my enumerated improvements to 494.
Please.
All right. The first thing is that all appointments of family law practitioners should be in writing. They're not. I mean, right now, later this week, my current guardian ad litem is going to fly out to Ohio to see my parents and see where I want to relocate my children. I have no idea what that's going to cost. I have no idea whether or not that's within the scope of her employment. None of the different family law professionals I've been ordered to pay have I had written orders that specify what they're going to get or what they're supposed to do. I think there should be fixed hourly rates and hard dollar cap on the billing. I think there should be no immunity. I will tell you that no guardian ad litem in the state of Connecticut has ever been held liable for any kind of malfeasance. That's true. I know that. I deposed the guy, a psychologist who admitted to having created the GAL training program and been doing this for decades. And when I asked him, are you aware of any example where any GAL in Connecticut has been held accountable for any level of malfeasance, he said, no. Judges should have no role in the appointment process. So even Section 1 of proposed Bill 494, I oppose because it lets the judges come up with a list of 5. Okay? And the problem with that is it creates a huge perception of corruption, and probably even actual corruption. So why did that judge pick that one specific lawyer by name to represent my guardian ad litem? It just doesn't feel good. And by the way, he showed up and announced he would be billing the family at his normal hourly rate of $850 an hour. Okay? That's crazy, right? These judges are giving away contracts. They're forced contracts. They're not what economists would call voluntary contracts, and it's not okay for them to be able to do that. So I think you have to take the judges out of the appointment process. All statements a guardian ad litem makes in court should be considered to be under oath. My guardian ad litem did all kinds of things that affected the amount of time that I had and my ex had with my children. But none of her statements were ever under oath. She never actually testified. The way family law is actually practiced, particularly in Stanford, is that you walk in, your parenting, your ability to represent the best interest of your children has been taken from you, has been given to a private, profit-maximizing individual who then tells the judge what she thinks. And almost everything that GAL says is actually inadmissible hearsay. Doesn't make a difference because she's not actually testifying. She's never been put under oath, and as a result of that, she's not liable for perjury. Accountability for retaliation. The one thing this bill does change is it creates a standing for parents to ask for the removal of a guardian ad litem. No parent will actually exercise that the way it's written. And the only reason I asked for the removal of my guardian ad litem was that it occurred to me there was no possibility that she could just give the kid to the other parent, okay, because of the extreme nature of my family's circumstances. What didn't occur to me was she could threaten to put my kids in foster care, which at one point she did, okay? If you leave this bill the way it is now, some of the people have testified that they're worried that parents will bring too many motions to have their GALs removed. My fear is no parent is going to ask for the GAL to be removed, because if you go for that and you lose, you're a toast. It's just, the risk is just way too high. Parents aren't going to do that. I think that there needs to be, at the time the family law practitioners are appointed, the judge needs to specify what the grievance procedures are. Right now, my GAL, the one who was removed, was a psychologist. There are no grievance procedures for psychologist GALs. Other parents who took grievances to lawyer GALs, to the lawyer grievance committee, had them refused because for a while the grievance board said they weren't acting as lawyers, okay? A lot of the other people who get appointed, the psychologists, the psychiatrists, the visitation supervisors, the evaluators, the conflict managers, the parenting coordinators, there are no ethical rules, there's no grievance procedure for that. So I think in any order that appoints and obligates a parent to pay for one of those professionals, the court should tell you what the grievance procedure is and should determine whether or not it's adequate. And then there should be follow-up so people can actually see what happens when you file a grievance and whether or not it's granted. The appointing orders for any family law practitioner should include a statement by the judge that the appointment is constitutional. Right now, people get appointed without regard to whether or not it's a constitutional exercise of judicial power. It doesn't matter. And as someone who currently has 2 federal civil rights lawsuits that Norm Pattis has filed on my behalf, this is very, very difficult to litigate in the family court, in the federal courts. If a state court judge abrogates your constitutional rights, you basically have an impossible task to fix that. Okay? So I think by obligating the judges to determine at the outset that the order is constitutional would at least give you a statement that you could build upon in federal court. You need to
Sergeant, if you have any further points, put them in writing, please, and submit them to the committee.
I will. I thank you very much for your time. I understand this is a very complicated issue, and I certainly hope that we can fix something this short session. Thank you.
Thank you. We appreciate your very comprehensive and hopefully effective testimony.
I guess I should stay in case you have any questions.
Are there questions? Thank you, Mr. Sargent.